Alright, so here we are. That was hers. Let's do his. I freed up some space. I had to move a couple of things around and freed up some more space so I can continue on my venture here. I'm going to try to read these a little bit faster. Now comes the defendant, nameless, by through undesigned counsel, nameless, respectfully moves this court in the following orders. Designate a defendant as the legal custodian of her minor child. It's not her minor child. It's no way ever been any shape, form, or part of her minor child. Never. I picked his name 10 years before he was born, just like I did his sister. They have my last name. I've had custody of him since he was 5 months old, just like I have her since she was 7 months old. The designated defendant as the legal custodian of her minor child until further order of the court. Review existing child support. Well, yeah, because you don't pay any child support. You never have in neither of their lives. I've provided everything for them myself. With just me and what I get alone, I've taken care of them myself alone. Any other court orders, any other orders the court deems necessary and appropriate for cause. The defendant asserts, is her in the best interest of the minor to be in her custody, and those reasons will be set forth more fully at the hearing above in the captioned manner. Motion filed. Now comes the defendant. I'm the biological and legal mother of this boy. Plaintiff, my name, is the biological and legal father of the minor child. Now, I'm the full custodial parent of him. I have been the full custodial parent of her and both of them since each of them was roughly 6 months old. When I paid my money for my DNA test, that I already knew I was the father. I didn't do it to prove that I was or wasn't for myself. I did it to prove that I was for the government. And though I could have spent $1 through Jobs and Family Services and done it for $1, I didn't do that. I paid, it was either $200 or $399 for hers, and $399 or $499 for his, because it was $100 more the second time. I don't think it was $299, $399. It was $399 or $499. Either way, I paid all the hundreds of dollars myself when I could have done it for $2, $1 for each of them. I did it myself, for myself, so that I could show later whose they are. And with the DNA testing for each of them that I included in the reports that you signed in this stack of papers when you signed your rights away, in this stack of papers here that is almost 7 years thick now. Honor is in the current legal custody of the plaintiff. I resided with the plaintiff and our minor children till approximately October 17, at which time the plaintiff kicked me out of the home. The plaintiff and I reconciled again. He kicked me out of the home in December of 2018. I have not seen the minor children since that time. It is not safe for either of the minor children to be in the legal custody of the plaintiff. Again, if this was unsafe in the latter months of 2017, then why is this only being brought to the court's attention in the beginning months of 2021? 2018, 2019, and 2020. 3 years. They're in such danger that it's taken 3 years for you to decide that you want to do this now. That's not protecting any children. If they was in any danger, you wouldn't have dismissed the case last time when you were afraid of going to prison for lying. You would have went through with it. If they were in any danger, then you would have never came back and reconciled or tried to. You would have filed the paperwork the first time when you hired Nikki Reed and obtained her and gave this affidavit the first of 3 times. You would have never had her not file the paperwork like you had her not file it the first time because you knew that it was full of lies and you were going to get busted. Remember? And you forgot that when it came to the second time. And then you were reminded. And it's been a couple of years, and so I'm curious, like, did you forget that you were going to go to prison because you purged your affidavit? Plaintiff is mentally unstable. He has a very bad temper. Well, you know what? That reminds me of something. I was the one that caught you in the bathroom at my mother's house before we moved into this house with the butcher knife ready to slit your wrist. I pulled the knife out of your hand. I called the suicide prevention place. I took you to inpatient care as you was there for a week. I took care of our daughter and our infant son for the whole time that you were inpatient and visited you so that you didn't go wacky loony nuts. There's record and documentation of that, too. Both children... Oh, wait. I have witnessed the plaintiff scream in the face of honor when he was 4 months old. Both children appear to be afraid of the plaintiff. Plaintiff frequently calls them both names such as Little Mother Effers. Well, I can tell you one thing. If it's anybody that's been documented, that's mistreating any of the children in any way, that's abuse, it's you. It's called abuse by neglect. And you have neglect of these children. You are not fit to be a mother. You have admitted on videotape, woman, that you're not fit. You cried tears saying that it's not your fault, that your mother didn't teach you how, but that you don't have the skills. And yes, that makes you sad and makes you feel like an absolute horrible person. But filing this affidavit as lies and purging yourself doesn't make you fit. It makes you further unfit, mentally unstable. If you are telling your attorney that I'm telling them you're dead, and your attorney filed this paperwork in a highly prejudiced, egregious manager, highly egregious manner, what does anybody think you're going to tell the children? If you're manipulating the court system saying that I'm saying that you're dead, what does a counselor or a therapist or CPS or social worker, what does anybody else think you're going to tell the children in private? The obvious, most worst, horrible lies you could even imagine. She said they're going to attempt to destroy these children and the hard work that I've done in healing their hearts and broken minds. Again, plaintiff has been physically violent with me. He whipped me with the belt. He spanks honor more frequently than he spanks freedom. Okay, well, let me tell you something about spankings. The last time that I whooped my son was over a year ago. Over a year ago. The last time I whooped him, he had a plastic car track, Hot Wheels, and he hit Freedom in the eye with it. That was the last time that I whooped him. That was over a year ago. And the last time I whooped her, I can't even remember if it was 2 or 3 years ago. It's been so long. It's been 2 or 3 years since I whooped her. So you know nothing. You don't know me. You don't know them. You don't know us. They don't know you. I know everything. But I've also documented everything. And I can prove and show the truth to anybody, everybody. Plaintiff does not care for the medical and dental needs of the children of the minor had bottle rot. Yes, he did. And the dentist that performed his surgery, that I took him to, that you dipped out a month or two before, said, clearly this is nothing that has happened in the past 6 months from October until now. This has happened as a matter of years. We can see the decay on the teeth. We know the age of the decay on the teeth is 2 and 3 years old. It's somewhere roughly around 2.5 years. You would have been here giving them Kool-Aid at that point. I told you the Kool-Aid man doesn't have any teeth for a reason, because it'd be false advertisement. Plaintiff has told me he will not take him to the dentist because they put mind control chips in people's mouths. Plaintiff did not take the dentist to the children until Stark County Jobs Department of Family Services got involved with the family in 2018. Again, that is a lie. She's painting a picture for me to look crazy, like I'm insane, when the fact is, Jobs and Family Services has never been involved in my children's lives. Ever. For the sense they came here once, inspected my children, said there is no cause for case, and left. That was the extent of CPS, Child Protective Services, any social worker, whatever, whoever, whatever. Anybody at Jobs and Family Services or any government official or whatever, the extent of them being involved in my children's lives was stepping at the threshold of my back door, inspecting my children with their physical eyeballs and saying, I'm satisfied. They're safe. They're healthy. There's no cause for concern here. And it's on videotape. I have everything on tape. I've been nothing but protecting my children since the day they were born. For an attorney to file this paperwork, never investigating a piece, never researching a shred, never having a shred of evidence, never having a piece of any part of proof that any of these words are true, is highly prejudicial and highly egregious. Period. Exclamation stamp. The plaintiff was told to take honor to speech therapy by a doctor, and he did not, until Stark County Jobs and Family Services got involved with the family in 2018. Again, that is not true. That is not true. There was never been any involvement from Jobs and Family Services, and in fact, on another part of this paper back here, in one of your other affidavits, because you have your income and expenses affidavit, it's not filled out, and many places left blank and empty, which is not supposed to be that way. It's not fully filled out. You even said, oh no, it was up here already in the motion to in the affidavit of defendant. You had said that you had tried to get Jobs and Family Services involved, but they wouldn't. Oh, okay, so I'm not even at that part yet. Okay. That's my fault. So, again, if you're an attorney, and it's your job to protect children, and part of protecting children is obviously doing your job, filing these papers, to look out for the best interest of the children, not the mother, not the father, the children. Not your client, not the liar, your children. The children. I find it highly egregious and highly prejudiced that you would be so unaccountable and so irresponsible to file this paperwork with any court without having a shred of evidence or any piece of proof whatsoever. That is not a responsible thing to do for any attorney, let alone ones that is supposed to be looking out for the best interest of children, providing protection for them. That is about as corrupt gets. Now, if you had no idea of any of this, you do now. If you had no idea that this was the case, you do now. You have a responsibility to drop your client and dismiss this case with prejudice. Even if it was accidentally, initially, at this point, afterwards, it would be on purpose.